This is the second video in our series of 4 videos looking at how rights are protected in Australia. As I've said in the previous video, there are 4 ways in which rights are protected in Australia: through statute, through the common law, under the Australian Constitution, and through international declarations and treaties. In this video, we are looking at how rights are protected in Australia through the common law. There are 2 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause function so that you pause this video whenever you need to take notes. And also make sure that you use the rewind function so that you rewind this video if you've missed any information or if you need to go back over any information in the video. Once you have finished watching and taking notes on this video, please read section 15.3 of the textbook and supplement your notes with any information from that reading that you find useful. Here is your learning intention for this video. That is, you should be able to evaluate the ways in which rights are protected in Australia through the common law. Make sure you write this learning intention down in your Cornell notes. This slide is by way of recap, and it sets out in a little bit more detail the 4 ways in which rights are protected in Australia. As we saw in the previous video, the first way in which rights are protected in Australia is through statute law. There are statutes that have been passed by the Commonwealth and Victorian parliaments that protect many of the rights that we enjoy today. For example, there is legislation that prohibits people being discriminated against on the basis of gender, sexual orientation, religious beliefs, and race. Put another way, these statutes give us the rights not to be discriminated against on the basis of our gender, sexual orientation, religious beliefs, or race. In addition, in Victoria, we also have the Victorian Charter of Human Rights and Responsibilities, which sets out some of the rights that the people in Victoria enjoy. The second way in which rights are protected in Australia is through the common law, and that is the subject of this video. The common law is law made by judges when they are deciding cases. So, for example, as we've seen, it's through the common law that we have the right to silence and the right to a fair trial. These are rights that judges have developed through making decisions in cases that they have heard. The third way in which rights are protected in Australia, and which will be the subject of the third video, is under the Australian Constitution. The Australian Constitution protects various rights by restricting the law-making powers of Parliament. For example, the Australian Constitution prohibits the Commonwealth Parliament from making laws that restrict freedom of religion. The fourth and final way in which rights are protected in Australia is through international declarations and treaties. The Commonwealth Government has entered into a number of international declarations and treaties. One example is the Universal Declaration of Human Rights. These instruments, that is, these declarations and treaties, impose obligations on Australia to protect various rights. However, importantly, these rights can't be enforced by the Australian people until the Commonwealth Parliament has passed legislation that gives the Australian people these rights. The focus of this video is on rights that are protected by the common law. The common law is law that is made by judges when they are deciding cases. Now, the issue with rights that are created by the common law and therefore protected by the common law is that Parliament can take those rights away from us. And this is because Parliament is the supreme lawmaker. This means that Parliament is able to abrogate or override the common law to change or remove these rights. Put another way, if there is a court decision that creates a particular right and Parliament disagrees with that right, then Parliament can simply pass legislation that overturns the law that created that right in the first place. On this slide, I've given you two examples of rights which are created by and are therefore protected by the common law. The first is the right to silence, and the second is the right to a fair trial. Under the right to silence, no inference of guilt can be drawn from the failure of an accused to answer police questions or to give evidence at their trial. This right to silence was reaffirmed by the High Court in the case of Petty and the Queen. What this means is that a jury or a magistrate can't make any conclusions about the guilt of a person simply because that person refuses to answer police questions when they've been arrested, or because that person doesn't give evidence at their trial. This is entirely consistent with the presumption of innocence, because a person who is presumed innocent doesn't need to answer questions asked by the police, doesn't need to give evidence at their trial. An accused never has to prove their innocence. Instead, the burden of proof is on the prosecution. That is, it is for the prosecution to prove beyond reasonable doubt that the accused is guilty of the crimes or offences with which they have been charged. It's entirely right for an accused to sit back and say nothing and leave it to the prosecution to prove that they committed the offence if the prosecution is able to do so. And if an accused exercises their right to silence, then neither the jury nor a magistrate should draw any inference, that is, any conclusions about the guilt of that person simply because they are refusing to answer questions or to give evidence. The right to a fair trial was reaffirmed in the case of Dietrich and the Queen. I gave you a handout in class which summarised the case of Dietrich and the Queen. You'll remember that Dietrich, the accused, was charged with two offences. The first offence was the offence of importing drugs, and that related to some heroin in condoms that the police said Dietrich had swallowed and that he had brought into Australia from Thailand. The police said that they had retrieved those condoms after sitting Mr. Dietrich on a bucket in an isolation ward of a prison. Nature had taken its course and Dietrich had passed the condoms through him. The second charge related to the possession of heroin, and this charge arose out of heroin in a plastic bag that the police said they had found when they were searching Dietrich's flat. Now, in this particular case, Dietrich pleaded not guilty to both charges, and he applied for legal aid because he didn't have sufficient money to employ a lawyer to defend him against these charges. The Legal Aid Commission, they agreed to provide legal aid to Dietrich, but only if he pleaded guilty. But Dietrich insisted that he was not guilty, and he wanted to plead not guilty. So as a result, he was not given any legal aid, and he had to defend himself. Now, the trial, which was held in the county court, lasted for 40 days, and during that time, Dietrich had no legal representation. He had to represent himself, and of course, against him, the prosecution had a legal team. So Mr. Dietrich was at a severe disadvantage. The High Court in the Dietrich case held that Dietrich had the right to a fair trial. Indeed, all accused people have the right to a fair trial. They said that in this case, Dietrich had been denied the right to a fair trial because he was unable to afford and was not given legal representation. Now, what difference would a lawyer have made? Well, the jury in this case found that Dietrich was not guilty of the charge of possessing heroin, that is, the heroin in the plastic bag. And the implication of this was that the jury was not satisfied that the police themselves had not actually planted that heroin in Dietrich's flat. Now, the jury did find Dietrich to be guilty of the charge of importing the heroin, that is, the heroin in the condoms. But the point the High Court made was that if the jury was not satisfied that the police had not planted the plastic bags of heroin in Dietrich's flat, then a good lawyer could have made a pretty credible argument that the police might also have planted the heroin that was found in the condoms. That is, they had simply filled the condoms with heroin and stuck them in the bucket when Dietrich had gone to the toilet. So Mr. Dietrich hadn't actually swallowed the condoms full of heroin and imported them with him from Bangkok. So what the High Court said was that if Mr. Dietrich had had a lawyer, then that lawyer might have been able to persuade the jury that Dietrich was not guilty of importing the heroin in the condoms. Put another way, the fact that Dietrich didn't have a lawyer meant that he was deprived of a reasonable opportunity of acquittal, and that in turn meant that his trial was not fair. So the case of Dietrich stands for the proposition that where an accused has been charged with a serious crime and wants legal representation but can't afford it, then to avoid the trial being unfair, the trial judge should stop the trial, that is, adjourn the trial, until the accused has been provided with legal aid. And again, the rationale for this is because everyone has the right to a fair trial, and if an accused who's been charged with a serious offence wants but cannot obtain or afford a lawyer, then that person will not have a fair trial, because the whole point of having a lawyer is that lawyers are experts at gathering evidence and presenting cases, and without a lawyer, then it's quite possible that an accused will be deprived of a reasonable opportunity of acquittal. Recall the learning intention. This was that you should be able to evaluate the ways in which rights are protected in Australia by the common law. Now, there are two requirements for an evaluation. The first requirement is that you need to weigh up the strengths and weaknesses of the thing that is being evaluated. In this case, you need to be able to weigh up the strengths of the common law as a way of protecting rights and the weaknesses of the common law as a way of protecting rights. This is also what you need to do if you are asked to discuss the common law as a way of protecting rights in Australia. The second requirement, though, is that for an evaluation you need to give an opinion. So in this case you would need to give an opinion as to the effectiveness of the common law in protecting rights. In class, we have been working on how to write evaluations. So this video is going to concentrate on the first of these requirements, that is, the requirement to weigh up the strengths and weaknesses of the common law as a way of protecting rights. As I've said before, I find a good way of preparing for these kinds of questions is to draw up a table that sets out the two sides that we're looking at. That is, the strengths of the common law as a way of protecting rights on the left-hand side, and the weaknesses of the common law as a way of protecting rights on the right-hand side. And again, because we're trying to compare apples with apples, what we do when we're setting out these strengths and weaknesses is to try to match each strength as far as possible against a related weakness. So let's talk through this table. The first strength of the common law in protecting rights is that the courts are able to make law, which we've previously referred to as precedent, to establish rights quite independently of the influence of government and parliament. So this is a strength because the courts are independent of government and parliament, and in the course of making their decisions in an impartial and independent way, they can develop the law so that it creates and recognises rights. However, a court cannot make a law that recognises a right unless it is deciding a case that raises an issue. Remember, the common law is law made by judges when they are deciding cases. Unlike Parliament, a judge can't simply get out of bed in the morning and decide to make up a law. Instead, the judge can only make law when the judge is presented with a case that raises an issue concerning that law. And a case can only be brought before a court by a person who has a direct interest in that case, that is, by a person who has standing. Of course, in addition to having standing, to be able to bring a case before a court, a person also needs the money and the time to bring that case. cases can take a long time to argue and to prepare, and certainly you need money if you're going to engage lawyers to bring your case to court. Going back to the strengths of the common law in protecting rights, the second strength is that when deciding a case, a court can highlight a gap in the law where rights need to be protected. And this is a strength because it means that a message is then sent to Parliament by the court that there is a gap that needs to be filled, and maybe Parliament will fill that gap by passing law. So it could be that in the course of a court decision, the court says, well, this person should have a right that they can enforce, but the law doesn't recognise that right, and that is a signal to Parliament that if Parliament agrees with the court, then Parliament should pass a law that establishes that right. However, the related weakness, is that because Parliament is the supreme lawmaker, if it disagrees with a court decision creating a right, then it is able to abrogate, that is, override the law created by that court, and in doing so, it can change or remove the right that has been created by the court. That then brings us to the end of this video. Remember, by now you should be able to evaluate the ways in which rights are protected in Australia by the common law. Please remember to read section 15.3 of the textbook and to supplement your notes with any information from that reading that you find to be useful. Thank you for your attention.